Dear viewers, welcome to another episode of Editorial Analysis by Drishti IAS. Through this program, we focus on important editorials from major newspapers such as the Hindu, the Indian Express, Live Mint, Business Standard, etc. for effective understanding for our viewers. Now, through this program, we focus on three things. Firstly, we try to establish a link between the editorial and that of the UPSC syllabus. Secondly, we focus on the key points that are mentioned in the editorial. And lastly, and most importantly, we try to learn the key concepts as mentioned in the editorial. Hope you are liking this new initiative of Dristhi IAS. Please feel free to give us your valuable suggestions so that we can strive to do better every day.
Dear viewer, this video is available in Hindi as well. If you wish to watch it, please visit our Hindi YouTube channel, Drishti IAS. For your convenience, the link for this video in Hindi has been provided in the description below.
For today's editorial, we have opted for the article Seal of Justice from the Indian Express, dated 13th August 2020. The editorial talks about the recent judgment by the Supreme Court on the Hindu Succession Amendment Act of 2005. Before we go ahead to learn about the editorial, let us try to link it with that of the UPSC syllabus. The main focus would be from mains perspective. From General Studies 1 perspective, we can narrow it down to role of women. While from General Studies 2 perspective, we can narrow it down to constitution, polity, and also welfare schemes for vulnerable sections, the mechanisms, laws, institutions, and bodies constituted for the protection and betterment of these vulnerable sections. Now, dear viewers, the basic idea of the editorial is about the judgment related to the Hindu Succession Act. But in order to understand that judgment and the issue, we need to learn this from a chronological perspective. So let us commence. Asking you to come with me towards the mid-1940s, the framers of the Constitution started working on the promise of gender equality by inscribing it in the Constitution of India. As witnessed, the principle is enshrined in the preamble, the fundamental rights, the fundamental duties, and directive principles. But coming back to our issue, the government had also tried to introduce the Hindu Code Bill, of which the Hindu Succession Act of 1956 was also a part. However, despite fierce opposition, the government was still able to introduce this Succession Act. However, in 2000, the 174th Law Commission report noted, and this is paraphrased in our own terms, that even though the right to property is important for the freedom and development of a human being, the framing of all property laws have been exclusively for the benefit of man. Now, to explain this further, as per the Succession Act, in a Hindu undivided family, HUF, henceforth, only the male descendants of an ancestor, their mothers, wives, and unmarried daughters were given property rights. Now, to explain this further, father, mother, they have a son, they have another son, and they have a daughter. The daughter is married off. Now, the father passes away. The property is directly acquired by only the sons and their families ahead. The daughter is completely rejected from receiving any property. Now, that is why the Law Commission decided to push for a change in this law that barred women from being considered as co-parceners or joint legal heirs of their father's property. The report was accepted by the government, and the Parliament in 2005 introduced an amendment to the Hindu Succession Act of 1956. Now, what did this amendment bring about? It simply stated that a woman would be a co-parcener by birth in her own right in the same manner as the son. which means she will also be having equal rights to the assets and properties of her father. However, in spite of this amendment, there is always going to exist a gap between law and its implementations. Also, interpretations of various judgments, the interpretations of this law had raised a lot of litigation, which narrowed down to one important question. And that is where we come to this judgment. Now, what was the question? The question simply was whether the amendment that was introduced in 2005 could apply retrospectively or dependent upon the father being alive in 2005. Now, what does this question mean? See, the amendment was brought about in 2005. So, what about the cases before that? Or what if the father was not alive before that? Does that mean that this is applicable to them? So, that is why on August 11, 2020, the Supreme Court, three-judge bench headed by Justice Arun Mishra, ruled that a Hindu woman's right to be a joint heir to their ancestral property is by birth. This is the most important point, and definitely does not depend on whether her father was alive or not when the law was enacted in 2005. However, interestingly, the Supreme Court also added certain caveat, which in simple terms means conditions. Now, to begin with, registered settlements prior to December 2004. The son and the daughter have agreed to give their consent to the property. That is, either the son receives the whole set or they have divided it equally between both of them. However, if it is a registered settlement, this is not going to be brought in front of the high courts. The high courts will not entertain such cases, because if this is going to be entertained, it's going to lead to a deluge of litigation. So the Supreme Court made it very clear that every registered settlement is done and dusted. There is nothing more that can be done to it. However, if it is an oral agreement, that is, the son and daughter have only agreed but have not registered this in any form, then it can attract litigation. However, now let us try to look at what is the impact of this judgment. Now, the SE interpretation on the equal inheritance to daughters is absolutely one more step towards ensuring gender justice, because it simply pushes for women who lack economic resources and are often marginalized by the male members of the family, which is very regularly witnessed in our Indian society. However, as per the editorial, there is also a way forward. The first question, now, does this judgment end or secure gender justice completely? Absolutely not. It is very far from being a reality in India. Why? Because there are several other inequalities, through caste, religion, and class that reinforces the secondary status of women, and we still have a long way to go. However, the positive point is that this judgment is in sync with the larger churn in Indian life. If you would have observed the recent Sabrimala temple judgment, the triple talaq judgment, the rights of women in Jammu and Kashmir, all are implying that women are simply using their constitutional rights to extract concessions from families and religions, and thereby pushing institutions towards major change. So with this, we hope we have tried to understand the article. However, let us summarize it once more. So what was the background? As per the 174th Law Commission report, the Parliament passed the Hindu Succession Amendment Act of 2005, wherein Section 6 was amended. The amendment recognized that women are also co-parceners or joint legal heirs for partition of property arising from 2005. However, this brought in a lot of different interpretations, and finally the question arose whether the amendment could apply retrospectively or depended upon the father being alive in 2005. However, what did the court rule? Simply stated that a Hindu woman's right to be a joint heir to the ancestral property is by birth and definitely does not depend on whether her father was alive or not, or when the law was enacted in 2005. However, a caveat was added. The Supreme Court said that all registered settlements prior to December 2004 cannot be opened. This is simply to avoid the number of litigations that could arise. To conclude, The essay interpretation on equal inheritance is definitely a step towards ensuring gender justice. However, we are far from achieving it completely in India because of several inequalities in caste, religion, and class that reinforces the secondary status of women. So, dear viewers, let us know your opinion on the judgment and let us know what we can do further to improve gender justice in the comments below. Now we move towards the next segment, that is the key concepts that we have to learn through the editorial. Of course, we focus beginning with the Hindu Succession Act of 1956. Now, the Mitakshara School of Hindu Law was codified as the Hindu Succession Act of 1956. As stated earlier, this was part of the Hindu Code Bill introduced by the Jawaharlal Nehru government that included the Hindu Marriage Act, the Hindu Succession Act, Hindu Minority and Guardianship Act, and the Hindu Adoptions and Maintenance Act. Now, the Hindu Succession Act, what did it do? It simply governed succession and inheritance of property, but only recognized males as legal heirs. This act is applicable upon Buddhist, Sikhs, Jains, and followers of Arya Samaj, Brahmo Samaj. However, they do not include Muslim, Christian, Parsi, or Jew by religion. Now, before we go ahead to the Amendment Act, let us try to look at what is the Mitakshara School of Hindu Law. Now, there are two schools of Hindu laws. One, Mitakshara Law School and the Dayabhaga Law School. The term Mitakshara is derived from the name of a commentary written by Vignaneshwara on the Yajnavalkya Smriti, while the term Dayabhaga is derived from a similarly named text written by Jimuta Vahan. The Mitakshara law is observed in almost all parts of India and further subdivided into the Banaras, the Mithila, the Maharashtra and the Dravidian schools, while Dayabhaga is keenly observed in Bengal and Assam. In this school of law, a son by birth naturally acquires an interest in the ancestral property of the joint family, while in the Dayabhaga school of Hindu law, the son does not automatically acquire ownership. He only acquires it on the death of his father. In the Mitakshara school of Hindu law, all members enjoy corporationary rights, that is joint legal heirship, during the father's lifetime, while in the Dayabhaga law school, sons do not enjoy corporationary rights when the father is alive. The share in the Mitakshara law school is not defined and cannot be disposed of, while the share of each corpusena in Dayabhaga school of Hindu law is defined and can be disposed of. Another important factor is that the wife, as per Mitakshara school of Hindu law, cannot demand partition but has the right to a share in any partition between a husband and her sons. Now, while in the Dayabhaga school of Hindu law, the same right does not exist for the women because the sons simply cannot demand partition as the father is the absolute owner. And now we move to the next concept, that is the Hindu Succession Amendment Act of 2005. The 174th Law Commission report had recommended this reform in the Hindu succession law. The amendment simply recognized women as corporationers or joint legal heirs for partition of property arising from 2005. Section 6 of the Act was amended to make a daughter also a corporationer by birth in her own right. The law also gave the daughter the same rights and liabilities in the corporationary property as she would have had if she had been a son. The Amendment Act is also applicable to ancestral property and to interstate succession in personal property. What does interstate succession mean? Where succession happens as per law and not through a will. It is important to remember that even before the 2005 amendment, Andhra Pradesh, Karnataka, Maharashtra and Tamil Nadu had already made this change in the law. And last, we move to the most important topic, that is gender justice. So what is gender justice? Gender justice simply entails ending the inequalities between women and men that are produced and reproduced in the family, the community, the market and the state. Now, for this perspective, the best way to understand this topic is through the Sustainable Development Goals, where we connect it with gender equality, Sustainable Development Goal 5. Now, from a global perspective, to understand the inequalities between men and women, let us try to look that 1 in 3 women have experienced some form of physical or sexual violence in their lifetimes. And to narrow it to our country, the 65.46% of the women are literate as compared to 82.14% of women. You see the inequality there, right? Now, in spite of the fact that we have 100% enrollment of girls in primary education, it's only 74.6% that are enrolled in higher education. Now, the child sex ratio in India for every 1,000 boys, that situation wherein it is only 990. Now, women occupy 48.5% of our population, yet they only form 27.4% of our workforce. And since we're talking about the constitution and gender equality, women only hold 11% of seats in the Lok Sabha. However, on the positive aspect, they hold 46% in Panchayati Raj institutions or third tier bodies. Now, with reference to provisions of gender justice, the Constitution of India, as mentioned earlier, Article 14, 19, and 21, guarantees the right of equality and freedom from sexual discrimination to Indian women. India is also signatory to the Convention for the Elimination of All Forms of Discrimination against women. Let us next move towards trying to understand the steps taken towards gender justice by the judiciary. To begin with the Mary Roy case, this is the Mary Roy versus State of Kerala, wherein the Supreme Court had ruled that the women of Syrian Christian community had equal rights to the property of their fathers. Secondly, the Vishaka guidelines, which is again based on a very important landmark judgment, Vishaka and others versus the state of Rajasthan. The guidelines form the basis for the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Acts 2013. In short, it is referred to as the Sexual Harassment Act. And recently, the controversial Shaira Bano versus the Union of India and others, wherein the Supreme Court in a 3:2 majority judgment held that the practice of triple talaq as unconstitutional. And recently, the Supreme Court has also clubbed and referred 4 cases of contentious religious practices to a larger 7-judge bench. And these are the entry of women to the Sabrimala temple, Muslim women's entry into mosques, female genital mutilation among the Dawoodi Boharas, and the entry of Parsi women married to non-Parsis to their temples. Now, with this, we conclude the key concepts and we move to understanding this issue from prelims and mains perspective. Now, from prelims perspective, very rare, but if necessary, the UPSC could ask questions related to the Hindu school of laws, probably about the Vishaka guidelines or certain cases, and definitely a question on SDGs, as this has been in use very often. But from mains perspective, women empowerment is an absolute favorite topic for the UPSC. Now, in 2019, the question had appeared: the reservation of seats for women in the institutions of local self-government has had a limited impact on the patriarchal character of the Indian political process. This is a very important topic for the UPSC. In 2019, another question was also asked, that is, empowering women is the key to control the population growth. So, a lot of these factors and judgments can be used to answer and diversify your questions. So, dear viewers, with this, we conclude today's session of editorial analysis. Hope we have done justice in trying to teach you this issue. Until next time, please stay safe and thank you.